My name is Umesh Rao. I have completed my law degree in 1985. Today's subject is external aid of construction. I have prepared these notes to law students. I have prepared it in a easy to read, listen and remember manner. I advise you to read the textbook once and concentrate on these points prepared by me. I have tried to give the best material. If any of you finds any problem, kindly contact me through my email. The table and contents. External aids. What is external aid? External aid are those sources called by the courts while constituting the statutes. It is external. From outside we are getting. These are all documents and statutes. There are several types of external aids. One, parliamentary history. Under parliamentary history, there are two categories. One, traditional view and modern view. Under traditional view and modern view, and English practice and Indian practice, that we have to study in detail. Second one is historical facts and surroundings circumstances. Under this, first comes subsequent social, political, economic developments and scientific inventions. And second, a reference to other statutes. Under reference to other statutes, statutes in PARI, assistance from earlier statutes, assistance from subsequent statutes. Next, dictionary, textbook and foreign decisions. What is parliamentary history? Parliamentary history, Parliament is always enacting the law. There are various stages involved, like before introducing a bill, government appoints commissions, inquiry committee, joint parliamentary committee, study group. Based on the above report, draft law is proposed. It is called a bill. Bill is introduced in the parliament and statement of objections and bill put up to the on the table of the parliament, Lok Sabha and Rajya Sabha. Bill has to pass through three stages: first reading, second reading and third reading. And in first reading, no discussion. Second reading, consideration, discussion and amendment. Third reading, bill is passed. Similar process in another house, Rajya Sabha. So both the houses approve a bill sent to president for assent, then bill becomes law. All these documents, records, materials created during the above stages constitute a parliamentary history. Now, question is whether parliamentary history is helpful for interpreting the ambiguous provisions. For this type, we have to study under two types of practice. One, English practice and Indian practice. According to the English practice, there are two types. One, traditional view and modern view. Under traditional view, outrightly rejects the parliamentary history. Under modern view, the report of the committee can be taken on the material relating to good aid to the construction. Indian practice, Supreme Court approved parliamentary history for resolving the ambiguity. There are types of debates on bill. What is the debates on bill? Speeches to the members of the assembly are inadmissible as an external aid to construction. Debates held on bill on the parliament is also not admitted aid to construction. When the terms of the statutes are plain and clear, it is inadmissible as an aid. When words are used in the language where more than one meaning, then only debates on the bill can be looked into as an aid. Next, another one is statement of objections and reasons. The statement speaks of the background, facts, circumstances which necessitate the enactment. It can throw enough light on the background of the law, but the statement of objections can be used to ascertain the true meaning of provision of law. It can be used to understand the background antecedent state of affairs. When the meaning of the statutes is ambiguous, it can be used as an aid. Statement of objections can be referred for the limited purpose. Third one is reports of commission, reports of inquiry committee, reports of joint parliamentary committee, reports of study group. So before introducing a bill in the parliament, government appoints commission, report on inquiry committee, reports joint parliamentary committee, and reports of study group for collecting the background information leading to legislation. Sometimes government itself issues white paper. It is permissible internal aid. Next topic is historical facts and surrounding circumstances. What is historical facts and surrounding circumstances? It is a state of things existing at the time when the law was enacted. This includes evils which prevailed at the time when the statute was passed. Evils are to be rectified by the enactment. When the language of the statute doesn't give any clue as to intention of the legislature, courts consider the circumstances prevailing at the time of general enactment. We have to take the help of the Hayden rules for interpretation. What is the common law? What is the mischief? What is the remedy? And what is the reason for remedy? The judges shall always make such construction to suppress the mischief and provide the remedy. Therefore, it is necessary to understand the subject matter of the statute. The court will take into account the historical facts which existed at the time of passing the statute. Court will consider surrounding circumstances also. So the historical interpretation cannot be adopted in every case. Courts cannot travel out of the language used in the statutes. It cannot control the clear language used in the enactment. Courts may refer to contemporary treaties, historical works, or pictures engraving as documents in order for construction. Limitation: it cannot be used to defeat the clear language of enacting statute. In case of conflict between the plain language will survive. This historical facts and surrounding circumstances is subdivided into two categories. One, subsequent social, political, economic, development and scientific inventions. Second, reference to other statutes. This also can be studied under three heads. Statutes in PARI material. Statutes at the same time. Assistant from earlier statutes and assistant from subsequent statutes. Now, subsequent social, political, economic development. What is subsequent social, political, economic development? This topic has considered two headings: one general act and another constitutional act. These are ongoing processes. Socio-political scenes change with the passage of time. Economic status improve due to the passage of time. New scientific changes keeps on coming. Yesterday's imagination becomes a scientific reality of today. Some new words emerge, old words go. Parliament could predict the future development, but law remains perpetual unless it is expired. In such circumstances, court is bound to construe a statute properly and remove hardships and make it more effective. Court not barred from searching the original meaning of the statutes. Court has to interpret a statute, circumstances which are not existed, situations which are unknown at the time of passing. So in circumstances, General language originally designed to apply to earlier technology may be applied to later development of technology. For example, Telegraph Act was introduced in 1863. Telephone was invented in 1869. So Telegraph Act has been held to include telephone also. Another example, Protection of Children Act was enacted in 1978. At that time, computer technology was not anticipated. Indecent photograph would also include data stored on a computer disk. Concept of textile is changing. New kinds of fabrics invented, new methods, new techniques, new process invented. All these are regarded as textile. So Indian penal code should be construed with reference to modern needs. Language of the constitution deserves liberal construction. See, Article 360 of the Constitution confers powers on the Parliament to amend the Constitution and provide procedure for the same. As per Indian Penal Code, husband having sexual intercourse with his wife without her consent is convicted of rape. It is a Sexual Offence Act 1976. Second category is Constitutional Act. Language of the Constitution is to include the future developments in the various fields of humanity, then restricting the meaning at the time of passing the Constitution. It includes framework of the government, mechanism for making the laws, and resolution for constitutional disputes, and distribution of powers between states and center. Constitution must not be interpreted in a narrow meaning. Third one is statutes in pari materia. Pari means same, materia means subject matter. Pari materia means same subject matter. That means statutes in same subject matter. Pari materia means when statutes deal with same subject, same person, same thing. That means related provision is in different acts but on the same subject matter. For example, Agricultural Income Tax Act 1939 held to be pari materia with Section 22 of the Indian Income Tax Act 1922. Now we will take some case law. Section 4 of the Prevention of Corruption Act 1947 says that proof that the accused has accepted any gratification other than legal remuneration, unless contrary is established by the accused that the gratification was accepted as a bribe, this section held to be in pari materia with the subject matter dealt by Indian Evidence Act 1872. The statutes in pari materia can be referred to determine the meaning of ambiguous word. In order to resolve ambiguity, help can be taken from other statutes provided that they are pari materia on the same subject matter. The meaning of uncertain word cannot be imported from any other statutes. The rule of extension of basic principle, this is, court is required to see that statutes as a whole. The basic rule is that where the same words are used in a similar connection into the statutes. Next one, when two statutes are not in pari materia, then what to do? When two statutes are not in pari materia, help of one cannot be taken to interpret another. When the same word is used in a different sentence or in different context, it bears different meaning, hence it cannot be called upon. Now, merits of the rule pari materia. It avoids contradiction between the series of statutes on the same subject matter. It allows the use of the earlier statutes in the later statutes. It permits the use of presumption regarding the use of later statutes. Help from earlier statutes may be taken. Now, help from earlier statutes. What is this earlier statute? When a word is already been assigned a particular meaning in the legislation, same word is repeated in the same context in the subsequent legislation. It is assumed that legislature has accepted the interpretation as the same meaning. When the language employed in the later statutes is the same as in the earlier statutes, It indicates the indication of the legislature that language so used in the later statute is to be same sense as in the earlier one. When statute is repealed and reenacted, the words in the repealed statutes is reproduced in the new statutes. They should be interpreted in the same sense. For example, amending act. The power to make law vests with the legislature. Power to amend the existing vests with it. So amending act may replace certain provision or add new sections to the statutes or alter the language of the statutes. Next one is help from subsequent legislation. Normally, an earlier statute is referred to in resolving ambiguity in a later act. But later statutes is generally not used as an aid to construction of an earlier act. Next topic is dictionary. Dictionary is a book explaining the words of a language. It contains meaning of various words used in the language. It gives definition to each word. The purpose of dictionary is to provide meaning of a word. If a word is strange, dictionary may be referred to get its general meaning. Most of the modern statutes contain definition in the beginning. Supreme Court stated that if a word is not defined in the statute, dictionary may be consulted. Supreme Court held that dictionary meaning cannot be relied on where there is express statutory provision and plain meaning is available. Limitation of dictionary. When the language of a provision is plain, dictionary is of no use. Dictionary may be consulted only when the word is not defined. Another source is textbook. Sometimes court to arrive at a true meaning of the enactment taking help of textbooks. But if not necessary, that views expressed therein area the views of the court. The court may differ the views expressed with the books. Court can take the help of textbooks only when the language is not precise and word is capable of more than one meaning. Courts can take opinions expressed by textbooks like Manu, Yajnavalkya, Vigneshwara, Jimutavana, Kautilya. Courts have taken help and frequently quotes the books by above authors. Another is the foreign decision. Foreign decision means decision delivered by the foreign court. Such decision assistance can be taken subject to the following condition. One, importance should be given to the language of the relevant statutes. Second, the circumstances in which the act was enacted should be studied. Third, Indian conditions should be taken into consideration at the time of making a decision. For example, Ramotar versus Assistant Sales Tax Officer case, it was interpreted on the basis of other constitution with regard to the foreign decision.